The defense attorney was already speaking when I raised my hand. "Mr. Callahan, sit down." He didn't. Instead, he leaned farther over the counsel table, finger aimed across the room toward the witness stand. "This entire proceeding is a waste of this court's time," he said. A few jurors shifted in their seats. I watched him for a moment, then I said quietly into the microphone in front of me, "Counselor, if you don't sit down right now, you're about to learn exactly how expensive disrespect can become." He still didn't sit. That was the moment the morning changed. My courtroom was already settled into the slow rhythm of a midweek trial. The jurors had their notebooks open. The court reporter's hands hovered above the keys. The bailiff stood near the rail with his arms folded. The case itself was not complicated. A civil fraud dispute involving a small manufacturing company and a former financial manager accused of moving company funds through a chain of shell vendors. The plaintiff's attorney had spent 2 days presenting records and testimony. The defendant sat quietly beside Mr. Callahan. Mr. Callahan, however, had spent most of the trial pushing the boundaries of what the court would tolerate. Interrupting witnesses, speaking over opposing counsel, standing long after I instructed him to sit. None of it was dramatic, but all of it added weight. Courtrooms operate on rhythm. When someone breaks that rhythm repeatedly, everyone in the room feels it. That morning, the plaintiff's final witness had just taken the stand, a forensic accountant. She had been calm, careful, precise through direct examination. Then Mr. Callahan stood for cross, and within 30 seconds, the temperature in the room shifted. "Isn't it true," he said, pacing slowly in front of the jury box, "that your analysis depends entirely on documents provided by the plaintiff?" The witness nodded slightly. "Yes, and you didn't independently verify every vendor listed in those records. I verified a representative sample." Callahan turned toward the jury with a small shrug. "Representative sample," he repeated. Then he turned back to her. "So in other words, you're guessing." Plaintiff's counsel stood immediately. "Objection. Sustained," I said. Callahan nodded as if he had expected it, but he didn't stop. He stepped closer to the witness stand. "So you're testifying under oath that this entire chart, Mr. Callahan," I said, he kept speaking, "represents money that was stolen, counsel." He stopped talking but didn't turn around. That pause told me more than anything he'd said. It was deliberate. He knew exactly where the line was, and he was leaning on it. He turned slowly toward the bench. "Yes, Your Honor. You will ask questions," I said, "not deliver speeches." "Of course," he smiled slightly. Then he turned back to the witness and continued. For about 2 minutes, the questioning stayed inside the rules. Then he did it again. He started arguing with the witness. When she answered calmly, he cut her off. When opposing counsel objected, he rolled his eyes. Juror number 6 closed her notebook and leaned back in her chair. I made a note of that. Jurors notice tone, always. The moment that pushed things further happened a few minutes later. Callahan walked back toward the evidence screen that stood near the jury box. "Let's look at Exhibit 42, he said. He clicked the remote. A spreadsheet filled the monitor. Rows of payments, vendor names, transfer dates. The forensic accountant had used it during direct examination to demonstrate how the defendant allegedly routed company funds through vendors that didn't actually exist. Callahan pointed at the screen. "This," he said to the jury, "is speculation dressed up as accounting." "Objection," the plaintiff's attorney said immediately. "Sustained," I said. Callahan kept pointing at the screen. "You're telling these people, Mr. Callahan." He lowered the remote slowly. Then he turned toward me and said something that made the courtroom go still. "With respect, Your Honor, the jury deserves to hear the truth even if opposing counsel finds it uncomfortable." The words themselves weren't unusual. But the tone was, and the way he said them while staring directly at the bench, that was different. I leaned forward slightly. "Counselor," I said, "this court decides what the jury hears, not you." A quiet ripple moved through the gallery. Callahan inhaled slowly, then he spread his hands as if to show patience. "Understood." But he didn't sit down. Instead, he turned back to the witness again, and the questioning resumed for about another minute. Then he did something I had not seen him do before. He ignored a direct instruction. The forensic accountant began explaining how a group of vendor payments had been traced to a bank account controlled by the defendant's cousin. Callahan cut her off mid-sentence. "That's an assumption, sir," she said calmly. "It's based on bank. That's an assumption." I spoke. "Mr. Callahan, let the witness finish." He kept talking. "That's an assumption, and you know it." The witness stopped. The jurors stopped writing. I felt the entire room settle into that particular silence that happens when people realize someone is pushing too far. "Counselor," I said. He kept facing the witness. "That's an assumption," he repeated. That was when I told him to sit down, and he refused. The bailiff shifted his weight near the rail. Callahan finally turned toward the bench again. "You're preventing me from cross-examining the witness," he said. "No," I replied. I'm preventing you from interrupting her. He shook his head slowly. This trial has already crossed into absurdity. That was the sentence that crossed the final line. Not loud, not theatrical, but unmistakably directed at the authority of the court. I reached for the small stack of papers beside the bench. The motion for sanctions had been filed the previous afternoon by the plaintiff's attorney after several discovery violations by the defense. I had reviewed it overnight, and I had decided to wait until that moment. Mr. Callahan, I said. He stopped pacing. Yes, you filed 3 discovery certifications with this court stating that all financial records had been produced. That's correct. I lifted the document slightly. Yet this morning, opposing counsel presented bank statements that your client failed to disclose. Callahan's jaw tightened. We addressed that. No, I said calmly. You explained it. The jurors were watching now, every one of them. I continued. Those records were obtained through subpoena, not through your discovery responses. Callahan glanced briefly at his client, then back to me. Clerical oversight. I paused. Then I said the next sentence slowly. This court does not consider hiding financial records a clerical oversight. I signed the order. The pen made a small scratching sound in the microphone. Mr. Callahan, I said, pursuant to Rule 37 of the Civil Procedure Rules governing discovery violations, I slid the paper toward the clerk. This court imposes monetary sanctions in the amount of $8,000 payable within 30 days. For a moment, no one moved. The jurors looked at Callahan. Callahan looked at the order. Then he laughed, not loudly, but enough that everyone heard it. That's unbelievable, he said. The word hung in the air. The bailiff's posture straightened. I folded my hands on the bench. Counselor, I said quietly, you may continue cross-examination once you compose yourself. Instead, he stepped forward. You're penalizing my client for defending himself. I am sanctioning you, I replied, for violating discovery rules. He shook his head again. This entire courtroom, I raised my hand. Stop, he didn't. This entire courtroom is biased. The silence that followed felt heavier than anything that had happened before. Several jurors slowly turned toward the bench. I watched Callahan for another 2 seconds. Then I said the words that appear rarely in a courtroom. Mr. Callahan approached the bench. He walked forward slowly. The microphones were muted, but everyone could see us. Counselor, I said quietly, you are 1 sentence away from contempt. He leaned closer. You're threatening me. No, I said. I'm informing you. For a moment I thought he understood. Then he said something that removed all doubt. Maybe someone should. That was enough. I straightened, and I turned the microphone back on. Mr. Callahan, I said clearly, you are now excused from further participation in this trial. His eyes widened slightly. What? Gather your materials, I said, and leave this courtroom. A few jurors exchanged quick glances. Callahan looked at his client. You can't do that. I nodded toward the bailiff. Yes, I can. The bailiff stepped forward. Sir, Callahan didn't move. Sir, the bailiff repeated. Callahan slowly closed his briefcase. Then he said one last thing. Unbelievable. He turned and walked out of the courtroom. The door closed behind him. The silence that followed was absolute. No papers moving. No chairs shifting. The defendant sat alone at the defense table. I looked at him. Do you intend to retain substitute counsel? I asked. Or would you like a brief recess to consult with standby counsel? He swallowed. A recess? I nodded. 15 minutes. The gavel tapped once. When we returned, the trial continued. The evidence resumed. The jurors listened. And the rest of the case unfolded without interruption. 3 hours later, the foreperson stood. The verdict was read, and the courtroom moved forward the way it always does. But as the jurors filed out past the rail, I noticed something. They glanced once at the empty chair where Mr. Callahan had been sitting that morning. Courtrooms remember moments like that, even when the room goes quiet again. When the jurors stepped out to begin deliberations, the courtroom lost the tight focus it had carried all morning. Chairs shifted. The court reporter leaned back from her machine. The bailiff closed the jury room door with a quiet click and took his position again beside the rail. At the defense table, the defendant sat very still. His original attorney's chair remained empty. The substitute counsel, an older attorney from the same firm who had arrived during the recess, was flipping carefully through the trial binders Mr. Callahan had left behind. I watched him for a moment. He wasn't rushing. He wasn't trying to impress anyone. He was simply making sure he understood exactly where the case stood. That calm approach was already changing the temperature of the room. Trials sometimes recover that way, when the noise disappears. When the posturing stops, when the facts finally get space to sit in front of a jury without interference. The substitute counsel stood slowly. Your Honor, he said, adjusting his glasses, with the court's permission, I'd like to briefly address the sanctions issue outside the presence of the jury once they return with a verdict. I nodded. That can be handled after the verdict is recorded. He gave a small nod and sat again. Across the room, the plaintiff's attorney was quietly organizing the evidence exhibits back into their folders. There were a lot of them. Bank statements, vendor contracts, transfer records. Every one of them had been walked through during the past 2 days, and one exhibit in particular had changed the direction of the trial. It had happened just before Mr. Callahan was removed. The forensic accountant had been explaining a pattern of payments routed through a vendor called Midwest Equipment Supply. The name sounded legitimate, but the address attached to it led to a small warehouse space that had been empty for 3 years. That alone had raised questions, but the real shift happened when the plaintiff's attorney introduced Exhibit 51, a short audio recording. I remembered the moment clearly. "Your Honor," the plaintiff's attorney had said earlier that morning, holding a small flash drive, "we'd like to publish Exhibit 51 to the jury." Callahan had immediately stood. "Objection." "Foundation," the plaintiff's attorney nodded. "We'll lay it." The witness on the stand had been the company's operations manager. He testified that he had received the recording from a voicemail system used for vendor communications. Then he explained something that made the jurors lean forward slightly. The call had been placed by someone trying to confirm a payment, but the voice that answered the call didn't belong to a vendor. The lights in the courtroom dimmed slightly as the audio played through the speakers. A phone rang once, twice, then a man answered. "Yeah," the operations manager's voice followed. "This is regarding invoice 774 for Midwest Equipment Supply." There was a pause, then the voice on the line said something that changed the energy in the room. "You mean the transfer from last week?" The operations manager replied carefully. "Yes." Another pause, then the voice said, "Just send the next one the same way." Several jurors looked toward the defense table. Because the voice on the recording sounded very familiar, the operations manager cleared his throat. "Your Honor, that voice belongs to the defendant." The defense had objected immediately. But the identification had been allowed subject to the jury's evaluation, and when the recording ended, the room had gone very quiet. That was the moment when Mr. Callahan began pushing harder, interrupting more, arguing louder, trying to disrupt the direction the evidence was taking. Sometimes attorneys do that when they sense a shift they can't easily control, but the courtroom is designed to absorb that pressure, and eventually, procedure takes over. 28 minutes passed before the bailiff's radio buzzed softly at his belt. He glanced at it, then looked toward the bench. "Your Honor, the jury has reached a verdict." The courtroom straightened immediately. Chairs slid forward. The substitute defense counsel stood. The defendant exhaled slowly and adjusted the cuffs of his shirt. "Bring them in," I said. The bailiff opened the jury room door. "Ladies and gentlemen of the jury." They filed back into the box one by one. Juror number 3 held the verdict form in both hands. "Has the jury reached a verdict?" I asked. The foreperson stood. "We have, Your Honor." She handed the form to the bailiff, who passed it to the clerk. Paper moved quietly across the desk. Then the clerk began reading. "In the matter before this court," the defendant stared straight ahead. The substitute attorney placed one hand lightly on the edge of the table. The clerk continued. "On the claim of fraudulent misrepresentation," a pause, "we find in favor of the plaintiff." No one moved. The clerk read the remaining findings. Liability confirmed. Damages awarded. The jurors sat still while the words settled across the room. The defendant lowered his head slightly, not dramatically, just enough to show the verdict had landed. The substitute attorney leaned closer and spoke quietly to him. Across the aisle, the plaintiff's attorney remained seated, hands folded together, professional, contained. When the clerk finished reading, I looked toward the jury. "Members of the jury," I said, "this court thanks you for your service." Several jurors nodded. The bailiff escorted them from the room, and just like that, the trial phase ended, but one matter remained. I looked toward the substitute defense counsel. "You requested to address the sanctions issue." He stood. "Yes, Your Honor." He approached the podium slowly. "I want to be clear that the conduct that led to the sanctions order this morning was not reviewed by our firm before trial." He chose his words carefully. "And we respect the court's authority on the matter." I nodded. He continued. "My client understands the seriousness of the court's ruling." At the defense table, the defendant remained silent. The attorney finished. "We simply ask for clarification regarding payment scheduling." I glanced briefly at the order. 30 days remains appropriate," I said. He nodded once. "That's understood." The courtroom was nearly empty now. Gallery seats had cleared. The clerk was organizing files. The court reporter was already disconnecting equipment. The defendant stood quietly beside his attorney. There was no shouting, no outbursts. Just the quiet end of a long day in court. I looked once toward the defense table, where Mr. Callahan had been sitting that morning. The chair was still pushed slightly back from the table, exactly where he had left it. The bailiff noticed it too. He walked over and slid the chair neatly back into place. Then Then he returned to his post. Courtrooms always settle themselves again after moments like that. The room returns to order. The chairs line up. The papers stack neatly, and the next case eventually takes its place at the same tables.